Social workers have a central role within the local authorities with a duty to promote, support, and safeguard the well-being of all children in need in their area, insofar as is consistent with that duty to promote the upbringing of children by their families by providing a range and a level of service. Hello, welcome to this episode of Family Law Nugget. My name is Christopher Aniche. I am a specialist accredited children's panel solicitor, a solicitor's advocate, and a resolution accredited solicitor. I'll be discussing with you in this episode Section 20 of the Children's Act. Usually Section 20 of the Children's Act is rather confusing to parents when they sign it and then they think they are bound by it. But in this video, I'll be demystifying what is Section 20 and when Section 20 can be used. Firstly, starting, what is Section 20? Section 20 is an agreement and is provided under Section 20 of the Children's Act. Under the Section 20 of the Children's Act, the local authority feeling that this child, your children, or the person, a child who you are caring for is suffering or likely to suffer significant harm, may request for you to sign this Section 20. Mark you, a Section 20 is a voluntary agreement. That means you're free to sign it, you're free not to sign it. But however, if you decide not to sign it, the local authority might take what we call a protective measure. So Section 20 is like, for example, when a child has come to harm in the care of the parents and the local authority intend to investigate it. Because they feel at that critical moment that that child remaining in your care might pose some risk to that child, they might ask the parents that they should sign Section 20. Section 20, like I earlier indicated, is just a mere voluntary agreement where you sign the Section 20 and this child could stay with the local authority or in the local authority's foster placement for numbers of days or weeks. But mind you, it cannot be in perpetuity. The local authority cannot just have your child stay with the foster placement for months because it's against the law. So when you sign a Section 20, it will allow the local authority to investigate the situation or put a protective measure. Usually when you refuse to sign a Section 20, the local authority might decide to do, for example, they might decide to issue proceedings or bring an application for an EPO, which is Emergency Protection Order, which they can obtain ex parte, meaning they can call the court, ring the court even out of hours to request for this matter for the child to be removed. Or in certain situations, they might inform the police about the situation, and the police thinking or feeling that having reviewed it, they feel yes, the child is suffering, might make what we call the police protection. They take out police protection. In that case, they do not need to go to court to remove your child from you, and they can do that for a maximum of 72 hours. So basically, in future, when the local authority asks you for Section 20, you are well within your right to tell the social worker or the local authority that you need to take instruction from your solicitor, or take advice from your solicitor in order for you to sign a Section 20. However, depending on the situation, the local authority might decide to take another route to remove the child. I hope it's now clear that you understand a Section 20 and when the local authority can use it. And also, there are other situations. It's not only when there are situations that requires this child's removal, your children's removal. There might be a case where the parents at a particular time is incapable of caring for this child. It might be for some days, it might be some weeks. They can just ring the local authority and request that this child is placed under Section 20. Mind you, the only person that can request for that is a parent who has parental responsibility. There have been situations where, for example, when both parents have parental responsibility, one is in agreement for Section 20, the other is not in agreement for Section 20, the local authority cannot go ahead to accommodate this child. So they might now explore the other route, like bringing an EPO, depending on the situation. I hope you have gotten the wing of the understanding about Section 20. In other of my videos, I'll be discussing some other critical terminologies or critical areas relating to children and family law. Please subscribe.